Yes, my dear students, today we will learn what is doctrine of eclipse under Indian Constitution. In the last lecture, we have seen that Article 13, Clause 1 and Clause 2 emphasizes the importance of fundamental rights, and any pre-constitutional law or post-constitutional law which comes in clash with fundamental rights, that law is void to that extent. Now suppose there is a pre-constitutional law, we call it existing law. If an existing law is inconsistent with fundamental rights, this law becomes inoperative with effect from 26 January 1950, the day of commencement of our constitution. But this law is not dead altogether. It is overshadowed by fundamental rights, and this law remains dormant. This law remains eclipsed, but this law is not dead. As you see, lunar eclipse, solar eclipse, they are also temporary. They are not permanent. Likewise, here also, whenever an existing law is inconsistent with fundamental rights, it becomes inoperative with effect from 26 January 1950. But this law is not dead altogether. Rather, it is eclipsed by fundamental rights and remains dormant. It is a good law if a question arises for determination of rights and liabilities incurred before 26 January 1950, and also for determining the rights of the persons who have not been given fundamental rights by Constitution of India. Like certain foreigners are not entitled to certain fundamental rights. So for those foreigners, there is no clash between existing law and fundamental rights because they do not have fundamental rights. But this law is good for past transactions. According to doctrine of eclipse, an existing law made before commencement of Constitution of India remains eclipsed or dormant to the extent it comes under shadow of fundamental rights or is inconsistent with it. But the dormant or eclipsed part becomes operative and effective again if prohibition brought about by fundamental right is removed by Constitutional Amendment Act. Say, for example, any pre-existing law which was violative of fundamental right to property under Article 31, that law will remain eclipsed by fundamental right to property. But if fundamental right to property is taken away by constitutional amendment, present position is that fundamental right to property is no more a fundamental nowadays. It has been taken away from Part 3rd, and Article 31 has been abolished, and new Article 300 capital A has been enacted by 44th Constitutional Amendment. So the pre-existing law, which was inconsistent with fundamental rights, remained eclipsed till 44th Amendment Act. And the moment 44th Amendment Act removed right to property as a fundamental right, the clash between fundamental right and existing law vanishes. And the eclipse caused by fundamental right is removed. There is no eclipse now because right to property is no more a fundamental right. The total clash we have to see, clash was between fundamental right and pre-existing law. Since right to property is no more a fundamental right, that clash is over, eclipse is over. Then that pre-existing law, which was consistent with fundamental rights, will revive again. the eclipse is removed, because right to property is no more a fundamental right. The best illustration of doctrine of eclipse is a leading case decided by Supreme Court way back in 1955, Bikaji Narayan Dakras versus State of MP. In this case, an existing law, that is pre-constitutional law, the name of the law is CP and Bihar Motor Vehicle Amendment Act 1947. This amendment authorized the state government to exclude all private motor transport operators from the field of transport business. That means the state monopoly was created by the government, that only government buses will operate and private motor transport operators were removed from the field of transport business. So by this amendment, in pre-existing law, the state monopoly was given to the government. Now this part of the law became void on commencement of Constitution of India, as it infringed Article 19(1)(g). I have a right to practice profession or carry on any trade, occupation or business. And government says that pre-existing law is there. According to pre-existing law, state monopoly is there. So that state monopoly came in conflict with my fundamental right of practicing any profession or to carrying on any trade, occupation or business. There is a direct clash between my fundamental right to do business and state monopoly. So this CP and Bihar Motor Vehicle Amendment Act 1947 remains inoperative with effect from 26 January 1950. It is eclipsed by my fundamental right to carry on any profession, trade or business. Now what happened later on? In 1951, Article 19(6) was amended by first constitutional amendment so as to permit the government to monopolize any business. Now, Supreme Court held that after commencement of and after amendment of Article 19 Clause 6, the constitutional impediment was removed and Impugned Act ceases to be unconstitutional and became operative and enforceable. So that old law remained nearly eclipsed for the time being by my fundamental right to carry on any trade, profession or business. The effect of first Constitutional Amendment Act was to remove the shadow and to make the Impugned Act free from all blemish or infirmity. Dear students, you can understand it like this, that pre-constitutional law was there which authorized monopoly of the business by the government. Then came 26 January 1950, Constitution was commenced. It became operative. So that monopoly business law came into direct conflict with my fundamental right of carrying on any trade, profession or business. Now again, by first constitutional amendment, the power of state monopoly in business, transport business was given to the government by first constitutional amendment. Article 19 Clause 6 was amended, that state can monopolize the transport business. So the old law which permitted monopoly in transport business, old law was eclipsed by fundamental rights with effect from 26 January 1950. It remained eclipsed till first Constitutional Amendment Act was passed. The shadow of fundamental rights was removed, and now the pre-existing law becomes valid. Pre-existing law before commencement of our constitution was eclipsed by my fundamental right, and this eclipse has been removed by first Constitutional Amendment Act. Similarly, my dear students, Article 13 Clause 2 deals with future laws. Future laws means laws made after 26 January 1950. Article 13 clause 2 says that state is prohibited from making any law which takes away or abridges any of the rights conferred by part 3rd. And a law made in contravention of Article 13 clause 2 shall to the extent of contravention be void, but such law shall be valid for non-citizens, because non-citizens are not given all fundamental rights in part 3rd. In other words, we can say that voidness is not in rem, that law is not void in its totality, but only to the extent of contravention of the rights conferred on the citizens. It's valid law, it's good law for non-citizens, but it may be bad law for citizens. So its voidness is not in rem. There is another important leading case, State of Gujarat versus Shri Ambika Mills Limited, decided by the Supreme Court way back in 1974. The ratio decidendi of this case is that just as a pre-constitutional law taking away or abridging fundamental rights under Article 19 remained inoperative, or it remained operative after 26 January 1950 as regards non-citizens, because it was not inconsistent with their fundamental rights. So also a post-constitutional law, which is enacted after 26 January 1950, remains operative as against non-citizens, because it was not in contravention of their fundamental rights. So dear students, any pre-constitutional law which takes away or abridges the rights conferred by Article 19 should remain operative even after Constitution of India came into force, not because it was valid when enacted, but because it was void only to the extent of inconsistency with fundamental rights, and its voidness was confined to citizens only. Hence, the law becomes inconsistent with their fundamental rights alone. It's not against the rights of non-citizens. The meaning of the word void is same both in Article 13 clause 1 and 13 clause 2. And for that reason, a post-constitutional law which takes away or abridges the fundamental rights should be operative as regards non-citizens. It is void only to the extent of contravention of the rights conferred by Part 3rd on all the citizens. So it was held that if a law is otherwise valid, if a law is otherwise valid and good and does not contravene any of the fundamental rights, the non-citizens cannot plead that the law is absolutely null and void and inapplicable to them. See, law may have double role. Why? Because fundamental rights are available to citizens, and if that fundamental right is not available to non-citizens, then non-citizens cannot plead that law is absolutely void and it should be inapplicable to them. No, they cannot say, because law is valid for non-citizens. Why it is so? Simply because it is inconsistent with some of the fundamental rights of the citizens. As I told you, this means that one law can have double role. It may be void for citizens but valid for non-citizens. So the law laid down in Ambika Mill's case is of great importance in explaining the removal of unconstitutionality by subsequent constitutional amendment. So the voidness in Article 13 Clause 2 means void as against persons whose fundamental rights are taken away or abridged by law. Non-citizens cannot take advantage of voidness as compared to citizens. Accordingly, in this case, it was held that Bombay Welfare Fund Act 1953 was valid in respect of non-citizens. It may be invalid for citizens. Ambika Mill, in this case, had challenged the validity of this act on the ground that its provisions violate fundamental rights of citizens, employees, and therefore they are void under Article 13 Clause 2. It was held that even assuming that Article 19 company was not a citizen, it was entitled to move High Court and seek remedy for infringement of its ordinary right to property, which is not fundamental right now. So the provisions of Bombay Welfare Act 1953 were not existent but were valid laws enacted by competent legislature in respect of non-citizens, and the company could not take the plea that its right to property was being taken away or abridged away without authority of law. Dealing with the question of revival of a void act by Constitutional Amendment Act, the Supreme Court held that Article 31 capital B and 9th schedule have cured the defect, if any, in the various acts mentioned in the said schedule as regards any constitutionality alleged on the ground of infringement of fundamental rights, and by express words of Article 31 capital B, such curing of defect took place with retrospective effect from the date on which acts were put on the statute book. Thus, a void act can be revived by Constitutional Amendment Act. Now, whether a pre-existing law or whether law made by the Parliament after commencement of Constitution, whether it infringes fundamental right or not, what is the test? How do you find out whether a particular legislation is violative of fundamental rights? The pith and substance of the matter and the object of the legislation are irrelevant to the question of infringement of fundamental rights. And the true test is the direct effect of the impugned state action on a particular fundamental right. You will have to see what is the direct effect of legislation on the fundamental right of the citizens. The word direct goes to the quality or character of the effect and not the subject matter. Later on, this test was further modified as direct and inevitable effect of state action, meaning thereby, what is the direct and inevitable effect of the law passed by the Parliament, whether it is directly and inevitably affecting the fundamental rights of citizens or not. If it is affecting, then we can say that proposed legislation passed by the Parliament has a direct and inevitable effect on the fundamental right of the citizen. And this process can be explained as doctrine of intended or real effect also. What is the intended effect of law on fundamental right? And what is the real impact of the law on fundamental right? Dear students, whenever we talk of infringement of fundamental rights, there is a presumption of constitutionality in favor of the law. All laws made by the Parliament are deemed to be not violative of fundamental rights. A person who claims that a law violates a fundamental right he must prove and satisfy the court that law is violative of fundamental right according to test which we have discussed right now. Now, sometimes there is a law made by the parliament and two interpretations are possible, out of which one will make it unconstitutional because it conflicts with fundamental right, while the other interpretation will save it from unconstitutionality. So the latter must be preferred over the former. We should have a presumption of constitutionality in mind, and that interpretation should be followed, which saves the law from unconstitutionality. Similarly, if a law is capable of broad or liberal interpretation and at the same time narrow and restricted interpretation, and if the broader interpretation brings it in conflict with fundamental right, whereas narrow interpretation creates no conflict with fundamental right, or it removes such conflict, then in those circumstances, narrow interpretation must be taken to save the law from unconstitutionality. Whichever interpretation is in favor of saving the law from unconstitutionality should be adopted. The best illustration to explain this doctrine is Kedarnath Singh versus State of Bihar, decided by Supreme Court in 1962, in which the court saved section 124 capital A of IPC. This section is nowadays very much in discussion in the newspapers. Few people are demanding that section 124 capital A of IPC should be abolished. This section deals with sedition and exciting disaffection to the government established by law. So court saved this section from unconstitutionality under Article 19(1)(a) by holding that for constituting an offence under section 124 capital A, speech must have tendency or intention of creating public disorder. The sedative speech can be banned in the interest of public order. It is a reasonable restriction on the freedom of speech and expression, falling in Article 19, Clause 2. Sedative speech amounts to offence under section 124 capital A IPC if it disturbs public order. Dear students, we have seen the definition of our law and law in force in Article 13, Clause 3 also. This Article 13, Clause 3 defines the word law and law in force. The definition of words law and law in force in Article 13, Clause 3 is inclusive or enumerative rather than substantive. This definition includes the following expressions. First of all, statutory law made by the Parliament is included in the definition of words law and laws in force. Statutory law made by legislature or any other subordinate authority under delegated lawmaking process like rules, regulations, notifications, bylaws, all are included in the word statutory law. And this list is not exhaustive because delegated legislation may appear under other names also like sub-delegated legislation. The Constitution of India itself and Order of President under Article 359 suspending enforcement of fundamental rights are not laws under this provision. If the President of India has passed an order under Article 359 and the enforcement of fundamental rights is suspended, so this presidential order is not part of statutory law. Similarly, delegated or subordinate legislation will stand nullified if parent act under which it is made is held unconstitutional, either under Article 13 Clause 1 or 13 Clause 2. It's quite obvious when the parent act goes, the rules or the subordinate legislation drafted and passed in accordance with parent act also goes with the wind. Likewise, dear students, the ordinance made by the President of India or governors under Article 123 or 213 of Constitution or rule making by other authorities will be laws in force under Article 13, and they must conform to the provisions of Part 3rd. Administrative orders of the executive also fall within definition of law. But administrative directions or instructions issued by the government for the guidance of its officers, not meant to be enforceable obligations, would not be law under Article 13, Clause 3. If such directions infringe the fundamental right of government servants or outsiders, they would fall within the definition of law. And dear students, the pre-constitutional uncodified personal laws also do not fall within definition of laws in force, like Hindu law, Mohammedan law. Then comes the second category of legislation, that is through custom. You know, when custom is very old, it takes the shape of law. And the term custom includes custom and usages. So if any custom is in derogation of any fundamental right, it will become inoperative with effect from 26 January 1950. You see, long-standing custom of preemption on the ground of vicinity prevailing in certain urban areas has been struck down, since it imposes unreasonable restriction on the fundamental right of property, which is now repealed. This decision was given by the Supreme Court in Santram versus Lab Singh. And of late, you have seen that custom of triple talaq is now held unconstitutional. Then comes the third category of lawmaking, that is through judicial decisions. We have seen in the very first lecture, dear students, that judiciary is not covered in the definition of state under Article 12. Judicial decisions are not laws under Article 13. Therefore, a judicial decision which is overruled on the ground of not being in line with fundamental rights does not become void ab initio. It may be overruled prospectively. The courts may allow its operation for a definite period beyond the date of overruling also. Like we have seen in I.C. Golaknath's case, the ratio decidendi of Shankar Prasad and Sajan Singh's cases was overruled prospectively. If you see the law of Germany, in Germany, the laws found against fundamental rights are allowed to operate until a definite period within which legislature may be asked to make a suitable law consistent with fundamental rights. The Supreme Court of Germany may allow that law to continue, say, for 6 months more from the date of judgment if the law was found against the fundamental rights of the citizens. So for 6 months, it will remain valid. And 6 months period is given to the parliament, the lawmaking body, to enact the law which is not violative of fundamental rights. So we have legislations as source of law. We have custom, we have judicial decisions as source of law. And we have to test all these three categories of laws again on the touchstone of Article 13, Clause 1 and 2, whether they are violating fundamental rights or not. Then you see we have Clause 4 added in Article 13, Clause 4, which was added by 24th Constitutional Amendment Act 1971. And if you see the language of 13 Clause 4, it says, nothing in this article shall apply to any amendment of this Constitution made under Article 368. Meaning thereby that whenever a constitutional amendment is made, the impact of Article 13 will not be there on that law. Meaning thereby that if Parliament has amended the Constitution under Article 368 and few articles are amended, so the impact of Article 13 will not be applicable on those constitutional amendments. Meaning thereby that constitutional amendment will take away your fundamental right and still it may not be declared unconstitutional. This was done by 24th Constitutional Amendment Act of 1971. Before that, we have seen the leading case of Shankari Prasad versus Union of India. In this case, first Constitutional Amendment Act 1951, which amended fundamental rights guaranteed under Constitution of India, was challenged on the ground that since amendment had the effect of abridging fundamental rights, it was not a valid law under Article 13, Clause 2. But Supreme Court rejected the contention and held that the word law under Article 13(2) did not include a law made by Parliament under Article 368, amending the Constitution. You see, when constitutional amendment is not coming in the definition of word law as used in Article 13(2), then it will be saved from the impact of Article 13, Clause 2, because the word law does not include constitutional amendments. It may include other laws, but not constitutional amendments. So in Shankari Prasad's case, Supreme Court said that the word law in Article 13, Clause 2 did not include law made by the Parliament while amending the Constitution. जब वो लॉ की डेफिनेशन में आएगा ही नहीं तो void नहीं होगा under Article 13, Clause 2. और void नहीं होगा तो it will take away your fundamental rights. Meaning thereby that by this ratio decidendi of Shankari Prasad Singh's case, you are undermining the fundamental rights. You are giving a backseat to the fundamental rights as compared to directive principles of state policy. The word law, as I was emphasizing, under Article 13, Clause 2, must be taken to mean rules, regulations, made in exercise of ordinary legislative powers, and not amendment of the Constitution, made in exercise of constituent powers, with the result that Article 13, Clause 2 did not affect the amendment to the Constitution. I have written in the bracket 4/3. This is a code word between you and me. 4/3 means that part 4th were given preference as compared to part 3rd, fundamental rights. This similar remained the position, similar remained the ratio. In Sajjan Singh versus State of Rajasthan, the ratio of Shankari Prasad was followed. The position remained 4/3. Directive principles of state policy assumed as supremacy, suppressing the fundamental rights 4/3. And the same judgment that the word law in 13, Clause 2 did not include constitutional amendments. Now see the reversal in Golaknath's case. In this case, it was held by a majority of 6:5 that the word law in Article 13(2) includes amendments to Constitution of India. अब आप ट्रैप में आ गए. You are now within the definition of word law in 13 clause 2, which includes constitutional amendments also. Now each and every constitutional amendment has to satisfy the test of voidness mentioned in 13 clause 2 and 13(1) also. Now the position is, after Golaknath's case, that if an amendment of the constitution abridges or takes away a fundamental right guaranteed by part 3rd, the amending act itself becomes void and ultra vires. अब ब्रैकेट में हमने लिखा है 3/4. Now 3 is up. Part 3rd of constitution is up. Fundamental rights are given preference. Directive principles are given a backseat. Why? Because the word law in Article 13 now includes constitutional amendments also. तो अब हर constitutional amendment को Article 13 clause 2 के टेस्ट से पास होना हो. And if it violates fundamental right, it will be void. This was a prospective overruling of the Shankari Prasad and Sajjan Singh's ratio decidendi from the date of judgment. Mr. Golaknath, who won the case, could not get the benefit of this decision because the decision was, ratio was operative from the date of judgment. इसको बोलते हैं जीत की हार. बाबा खड़क सिंह की स्टोरी सुनी है आपने, जीत की हार, कि गोलकनाथ साहब जीत तो गए मुकदमा लेकिन फिर भी हार गए. Why? Because the benefit of this ratio was not available to Mr. Golaknath. The decision was operative prospectively from the date of the judgment. Then came the 4th set of rulings, beginning with Keswan and the Bharti versus State of Kerala. In this case, the ratio decidendi of Golaknath was overruled, and it was unanimously held that 24th Constitutional Amendment Act, which inserted clause 4 in Article 13 and corresponding clause 3 in Article 368, was valid. All the judges agreed that under amended Article 368, all provisions of Constitution of India, including those enshrining fundamental rights, could be amended. Now again 4/3. The situation is 4/3. In Keswan and Bharti's case, the net effect is, when you say that you can amend each and every fundamental right, that means you are giving supremacy to directive principles of state policy or other provisions of the Constitution, and you are suppressing part 3rd, that is fundamental right. कभी कभी ऐसा लगता है ये सास बहू वाली स्टोरी है. सास और बहू में भी टसल चलता है. सास अपने mother-in-law always give instructions, policies to daughter-in-law, and daughter-in-law always fights for the rights. अब कौन किस पे dominate कर जाए depends on facts and circumstances of each family. यहाँ भी यही चक्कर चल रहा है. In the 2 sets of rulings, Sajjan Singh and Shankari Prasad, the fundamental rights were given preference as compared to directive principles of state policy. In Golaknath's case, the directive principles were given preference, fundamental rights were suppressed. But in Keswan and Bharti's case, once again, part 4th was given preference, fundamental rights were suppressed. However, in this case, the majority of 7:6 was of the opinion that basic structure or framework of Constitution of India cannot be amended. Therefore, even if an amendment of Constitution is not law within the meaning of Article 13, that does not exempt it from being invalidated on the ground that by violating a fundamental right, it could violate basic structure of Constitution of India. Hence, if any amendment of Constitution of India violates its basic feature, it will be held void. And in Minerva Mill versus Union of India, they equated part 3rd with part 4th. In the opinion of the Supreme Court now, the directive principles of state policy and fundamental rights are at par. So equation is 4 is equal to 3. So dear students, here we end this lecture. Thank you very much. Thank you.